Well, hello everybody. This is Ron LeGrand, and welcome to this very special webinar where we're going to deal with the Dodd-Frank issues. I'm going to give you the itinerary here and what's going to come down so you'll know what to expect. First of all, this is live. I'm with you live here right now, and shortly we're going to go into a recorded session, and then I'm going to come back live. The recorded session that we're about to hear is with myself and an attorney, Lee Siegel, who has investigated heavily the Dodd-Frank Act, as have I. In fact, you'll hear that on the recording. We've both spent an awful lot of time and resources to bring you what we brought you today to try to simplify this Dodd-Frank thing. In a minute, we're going to open up that recording that was recently taped at the Seller Financing Boot Camp here in Jacksonville, where Lee was live. That recording will last 55 minutes, and then I'm going to come back on live again and address the raising capital issue with the Jobs Act that went into effect and how it affects private lending and finding private lenders, and talk on that briefly. After that is over, I will be taking your questions live. Now, there's two ways that we're going to be handling questions today, which actually creates a logistical nightmare, but I think we're going to pull it off fine. Number one, you can submit your questions, and in fact, throughout the entire webinar, you can submit your questions online right on the screen in front of you by typing them in. However, we are aware that a lot of people are not watching the screen but are listening to this call today, because honestly, you're going to get as much from listening to it as you are watching it. There's nothing exciting going to be on your screen except the questions that we're doing the answers to. So if you are listening and you'd rather participate by actually calling an operator and getting in the queue, then we've set that up for you as well. So you can ask questions by typing them in right on the screen. We'll take them. We'll come back when I'm ready to take the questions. We'll take them along with the ones that you call in. When I'm through with my presentation on capital, I will give you a phone number and a code to call a conference line, which is actually different than GoToWebinar here, so that you can get in the queue with the operator and we don't have all that background noise. I'll give you those instructions when I'm through. Again, if you're watching this live, you can ask your questions along the way. If I do not get them all answered by our cutoff time at 2 p.m. Eastern Standard Time, I will answer them by email individually after it is over. I think we're going to get them all in, but if we don't worry, you're still going to get your answers. So all of you will receive a link when this is over where you can download the entire conversation, questions and answers included. You'll download that. It will likely be a 2-hour recording. Of course, we can't we can't let you download it until we actually fill in the blanks with the answers. So you all get that link when it's over. So with that said, I'm going to turn it over to the recording. So Emily, if you can start the recording now, I will be back in about an hour, and we'll take over from there.
Sitting beside me is Mr. Lee Siegel from Tampa. Attorney, came all the way up here just for you. Pretty, isn't he?
Never been accused of that before.
Never been accused of that before. All right. Anyway, what we're going to do is go through the report that I prepared, largely with his input, and discuss this Dodd-Frank thing and make the best sense out of it that we can, and educate you to the point to where at least you got something to work with when you get out here selling or buying with owner financing. Now, this is going to come with a huge disclaimer and disclosure that you cannot assume that you're getting legal advice here, even though there's an attorney up here. He ain't sending you a bill. Well, we can fix that, though.
We can.
What we're about to tell you is the best that we can determine from what we know, and Lee and every other attorney that I've ever talked to will tell you there is so much in this law, this 858-page law, that is up for interpretation. As usual, they did a great job of writing the law so that it's clearly understood by anybody who reads it. That was a joke, incidentally. I have prepared the questions that are in this report, which is being handed out to you, based on my knowledge of the real estate industry as it applies to us. There's a whole heap of stuff in Dodd-Frank that doesn't apply to us, but that's not my problem. My problem is to take care of us the best that I can. And as we go through this, you're going to have questions, and we're not going to answer them until we're through, or we'll never get through. So this is how this is going to work. We're going to discuss the points. He and I are going to go back and forth. We're actually probably going to disagree on some items. That won't be a shock, would it? No? Okay. And that's okay, because I can tell you right now, you put 5 attorneys against the wall and ask them the same question, and you're going to get disagreements galore.
You'll get 6 different answers.
6 different answers. Okay. And you know why they're all lying, don't you? Because their lips are moving? I ain't going to go there. Promise Lee I wouldn't do any attorney jokes.
I'll do the attorney jokes.
You'll do the attorney jokes?
Yeah.
All right, I might learn some new ones.
You might.
All right. This report that you have I created it based on actual conversations with 4 different attorneys, input from him, of which we hired him to do, and reading at least 7 or 8 other reports generated by other attorneys and non-attorneys, and all together is what you see here. Now, even in those reports, there were some conflicting opinions, but by and large, across the board, there was mutual agreements for the most part. There's just a few points and the reason there's a few points that are conflicting is because it's not clear in the law, to be honest with you. Now, the downside here is that, great, we have the law, but we have no case histories. We have no track record to go on. We have no evidence from previous trials that produced the evidence, which is pretty much relevant in all lawsuits. We got something to go on. Here it's all brand new. And my goal is that you aren't the case studies for future use. But never forget, when all else fails, you can serve as a warning to others, right? Let's start this off by reading something one of you just gave me, written by some, I guess, lawyer, and a lawyer in Wisconsin, and frankly, I think I wrote it. It says, in my opinion, the SAFE Act and Dodd-Frank included fixes to largely imaginary problems, i.e. consumers getting seller financing through fraudulent means or on unfair terms. I can offer no explanation for the restrictions on seller financing except that the legislation to fix the financial turmoil caused by large financial institutions was drafted by the lobbies for these same large financial institutions. Asking Dodd and Frank to guard the large bank henhouse probably makes less sense than asking Bernie Madoff to serve this function. At least this story would make enough sense to fool the public. There is no factual basis of which I am aware upon which to conclude that seller financing had anything to do with the financial meltdown. I absolutely couldn't agree with him more. The truth is, seller financing is about that much of the total financing going on in this country anyway. But hey, here we are. Do we get to make the laws? No, but we get to fire politicians, don't we? Yeah. All right. So let's get going. Let's start with this Dodd-Frank report on seller financing. Oh, I forgot. You're going to tell them about what you do in your practice.
Sure.
Cut you
Well,
off.
as Ron said, I have a practice in the Tampa Bay area. My office is
Speak up.
actually in Clearwater. I have a partner, Jill Shue. She practices with me. We opened up the firm back in 2007, coming right out of law school. And going through, I've had many real estate transactions, both on the buyer and the seller side. I do a lot of foreclosure defense work, keeping the big banks who are subject to truth in lending and all the consumer regulations in their place. And I do a lot of commercial transactions, contracts, securities, things like that. So pretty varied civil litigation, but I do have a big focus on the real estate market.
So you are one of those guys that goes after banks.
Oh yeah.
You're one of those guys banks fear. Huh?
Well, my last 10 foreclosure trials, where it was admitted that there was a mortgage and there was a note, and that my clients haven't paid in 4 to 5 years. Out of the last 10, who can guess how many of those the bank won a foreclosure on? 3. And all those 3 could have been appealed. Fortunately, my clients don't have the money to do an appeal or post a bond to stop the sale, but in the end they end up getting a waiver of deficiency and walking away from the house not owing any money, but the other 7 are still in their homes over 5 years and awaiting to be served a new lawsuit from probably a new bank, because I was able to prove that the bank that brought the suit didn't have standing to bring the suit.
Okay, so the moral of this story is, if you get into a foreclosure situation, you ought to be fully aware of your rights and approach someone who understands what they can and cannot do, and not some attorney who's never sued a bank and has no idea what they're talking about. As always.
You don't want a criminal defense attorney doing your foreclosure defense. You want a real estate attorney who understands the mortgages, the notes, and all the issues that go around with it, because attorneys are licensed to practice law, but that doesn't mean they're competent to practice every area of the law.
I never met an attorney that was competent to practice every area. In fact, let me cut that sentence off in the middle. No, I'm not going to do that. Competent to practice law in every area. There is no such attorney. And most of them will tell you that. But, some of them try to do things they really shouldn't be doing.
Exactly. That's the big problem, is you have to make sure that the attorney you hire knows what he's doing for what you want him to do. He may be a great criminal defense attorney, but he may not know thing one about writing a contract. And so that's not the guy you want writing your contracts.
All right. Turn to the first page on page 2 and see. Look at the disclaimer. It's very simple. I'm not an attorney. We're not giving you legal advice. In fact, you can't even trust the advice we're giving you. In fact, I wouldn't even believe it if I were you. Here it is in writing. But when you get back into the real world, you've got to verify your own facts. And honestly, these facts are going to change. Because as time goes on, and we actually get case study concerning this Dodd-Frank thing, we are going to have some changes. There's a lot of things in this law that I cannot imagine what earthly good they do, and I bet you over time they're probably going to be waived. So let's just get to them and get through them. And remember, when we're done now, you get to ask questions. So I'd be writing them down as I go, and I'm probably going to have to limit those. We can't be here all day doing this one thing. Let's start with the first one. The Dodd-Frank takes effect on January 10th, 2014, and changes the rules for seller financing for those not qualifying as exempt. You see, that's incorrect already, because it changes the rules even for those that are qualified for exempt. The most relevant changes are, and this report discusses each of these. 1, it requires every lender to consider the borrower's ability to repay. And from what I understand, even if you are exempt. Correct?
Yes, if you are lending money, you have a duty to make sure that the person you're lending money to has an ability to repay, and there's 8 specific factors, which we'll get into later.
We'll come back to that.
That you have to examine when you're doing that.
All right? Which is number 2. It requires the lenders to consider
There it is.
8 factors. We'll come back to it. It doesn't require you to prove those 8 factors, but to consider those 8. The onus is probably going to be on you if you ever got into any litigation. The lender must write a qualified loan. Well, actually there are non-qualified loans, but you want to write them. The rules are so stringent on those. We'll come back to that, what a qualified loan is. Requires lenders to wait at least 120 days of delinquency before foreclosing. Did you catch that?
Yeah, it's actually 120 days, and you have to give the borrower a chance to do some loss mitigation, or try to cure the default, give them a mortgage modification that's going to be able to let the borrower stay in the house.
Come back to it. Dodd-Frank combined with SAFE Act in various states will require all owner finance transactions, except the exceptions, to be originated by a residential mortgage loan originator. That's, well, again, I'll come back to that. Prohibits builders from selling with owner financing. Frankly, it couldn't be more clear on that one. Mm-hmm. That's not one up for debate. Sadly, if you build houses for some weird reason, you can't sell them with owner financing. Now, I have no idea what possible value that law is, except to limit my ability as a builder to rotate houses and provide more housing. But there it is. Eliminates balloons and negative amortization loans and requires fixed rates for 5 years with no prepayment penalties. Sellers who sell with owner financing more than 3 times a year will become mortgage originators and must comply with Dodd-Frank. And no forced arbitration clause is allowed in the buyer's note. So let's go through these and other questions. All right. First one is, what information am I required to get from buyer to prove their capability to repay? And this is in Subtitle B, Section 1411. And it's there for you guys to go read it for yourself. In fact, you ought to go pull up the Dodd-Frank law and read every word of it. Twice.
If you have nothing to do for a couple days.
And you ought to be doing this in bed at night while trying to get to sleep. At a minimum, creditors generally must consider 8 underwriting factors, and yet there's nothing in there that says I must prove in a file that all of these factors have been considered and have evidence of it.
Correct.
Am I correct?
It is a recommended guideline, which means until somebody actually sues a creditor for not considering number 6, we won't know if that's a required or a recommended guideline.
Number 1, current or reasonably expected income or assets. Now, shouldn't we do that anyway?
Yeah.
All right, I just went through that yesterday or today or whenever it was. And I will tell you that I told you that the debt ratio that is mentioned, and yet I see no evidence that it is required, is 43% debt ratio, total debt now, which includes the house payment. Do you see anything that was required?
No. I've seen numbers, I've seen the number 38 a lot, and I've seen the number 43, and 43 seems to be the maximum that is allowed.
But yet, it doesn't say if you exceed 43%, you're violating the law.
No, it doesn't.
Okay.
It's a guideline.
The guideline. Okay. Current employment status. In other words, if they're unemployed and they have no income, probably shouldn't sell to them. So in other words, should you prove that they are employed? A check stub would do the job. Mm-hmm. The monthly payment on the covered transaction. In other words, can they afford the payment? And you should probably use a 28% of gross revenue on that one. Does the PITI exceed 28% of their gross family revenue? Remember now, family revenue is husband and wife, all income. Now, I think you've got a little latitude here. I can tell you right now, FHA will absolutely have to have ironclad proof of that income. I think we can reasonably assume that the income on if they say to us, I make $1,000 a week at the flea market, I think we can reasonably assume that is correct. Would you agree?
You can assume it. It's more recommended that you ask them to see, let's say, a month's worth of bank statements to show the deposits from the flea market, because while they may not reflect those on their tax return, since they're probably running a cash business, you want to get some kind of independent third-party verification from them.
Yeah.
From some independent third party.
I didn't see any law that says that we can't finance them if they're screwing the IRS. Did you?
No.
Okay. The monthly payments for mortgage-related obligations, which I guess means other mortgages?
Association dues.
Oh, yeah. Got it.
Things like that.
Association dues. In other words, you have to add that, remember, to the payment if there is association dues. All right. The monthly debt income ratio, or residential or residual income, which we just discussed actually, and credit history. Now, credit history, okay. So what? I got their credit report. Well, what about it? All the people we finance, the FHA won't. So I don't know what to tell you about the credit report. I'd say I'd want it in my file. And I'd say if it's really, really, really atrocious and you still want to accept them, you probably ought to have some justification in there why you should. I think it's actually a good idea if you put a one-page report in each file that how you came to the conclusions you came to accept them. Don't you think so?
Yeah. What factors you considered.
Yeah. What
documents you reviewed. And that way, if anybody comes asking any questions, you have the one page to hand them and say, here's the answer.
And then it says creditors must generally use reasonable, reliably third-party records to verify the information they use to evaluate the factors. what's reasonably reliable, not defined. What third-party records, not defined. So common sense takes over. So here's what I want you to ask yourself. If I ever get attacked, am I going to be proud to take this file into court and defend myself? And that's the best you can do, guys. That is the best you can do. And by the way, I'd say if you have this file, there's little chance you're ever going to get to court. Wouldn't you agree?
Yes.
Yes? Okay. What is a qualified loan? Well, here you go. Here's the ugly part. It cannot have a negative amortization. No negative AMs. And it cannot have a balloon payment, which I'm telling you, I'll bet you the biggest lobster dinner in Jacksonville that that's going to change. Because I know for sure that NAR, National Association of Realtors, are petitioning to get that changed. Even they know how important that is to us in the world of seller financing. And if they don't get it positioned to be changed, I'll bet you there's some other groups that will. Because that is totally unfair. That is totally unfair to the seller. And Mr. Dodd, Mr. Frank, I hope you're watching this. You screwed up on that one, Bubba. That is totally unfair. Must have and must be for 30 years or less. In other words, I mean, what does that mean? Oh, right. We can't write a mortgage for more than 30 years.
Right.
Okay. That ain't a problem.
It's ironic because a lot of the mortgage modifications I'm seeing now offered to my clients have a 40-year amortization schedule.
But I bet they won't after January the 10th, will they?
Well, no, because this is a modification. It's not an original purchase.
Oh, so they can modify any way they want.
Oh, yeah.
Oh, so you're telling me...
The bank's already in the game.
Yeah.
So they've already given the bad loan. So now they're modifying it so they're not subject to Dodd-Frank.
So I wonder if I give a bad loan, can I modify it? No, we ain't going there. All right. Yeah, move your mic up.
Is that better?
Cannot have prepayment penalties in excess of a schedule set out in the regs. I don't know what the schedule is. The truth is, just don't have prepayment penalties and don't worry about it. You rarely would do that anyway on a seller carryback note.
The prepayment, I think, is 2% in the first 2 years and 1% in 3 years, and you can't have more than 3 years as a prepayment penalty. 3 years is the max.
All right. Can be a variable rate, but the underwriting must be based on the highest interest rate it can be during the first 5 years. I'm going to tell you you're probably a lot safer to not have a variable rate during the first 5 years. And we are going to discuss how to handle balloons and how to adjust, because we can't have balloons here. And the creditor must verify income and assets and debts through third party. We covered that. The creditor need not verify employment status per se, monthly payment per se, or simultaneous loans except as they fit into the debt to income ratio. Not sure why they wouldn't. If they have other obligations, they'd have to fit in the debt to income ratio, or would they? Maybe that means if they have a rental property, I don't have to consider that into their personal debt to income ratio. Do you know what that means?
If the rent is covering the mortgage, then yes, you could not include that in the debt to income because the income offsets the debt.
All right. The creditor need not verify credit history, but as a practical matter, we'll do so. We're going to verify credit history anyway, aren't we? Yes? Yes. All right. Okay, the 120-day rule. What is that, Lee?
120-day rule says that when your borrower starts becoming late, in the old days, as the banks would call them, the good old days, you send them a letter that says you have 30 days to cure this default. If you don't cure the default, we will accelerate your loan, demand the entire balance due, and start foreclosure proceedings. That's gone. You now have to wait a minimum of 120 days, and during those 120 days, you have to make a good faith effort, another term that's not defined, to contact the borrower and try to work out something with them in the form of loss mitigation, modification, get involved in the short sale negotiation with them, or have them do a deed in lieu of foreclosure.
Well, if I have a problem with them, my first goal is to get a deed in lieu of foreclosure anyway. So what would you suggest? First, we should issue them, now it's not a 30-day notice, it's a 120-day notice.
Yes.
But that notice should be issued immediately
Oh, yeah,
upon default.
upon default.
And then I think we probably should send a letter offering a deed in lieu of foreclosure. Wouldn't you agree?
Right away, because that saves both parties
Yeah.
a lot of time and headache. If the borrower is a reasonable person, they've come to the realization they were able to afford it, circumstances have changed, they're not able to afford it, easiest way out, deed the property back to your lender and walk away. You don't owe them any money, they get the house back.
That's the way you want to get out anyway, guys. Long before Dodd-Frank. Your whole goal is to go to them and peacefully say, look, I don't want to come after you. I don't want to destroy your credit. Give me the house back. Get out. Come back and see me when life turns around again, and I'll give you some credit for the down payment you gave me toward another house. That's the way we handle it. And that eliminates most of your problems. But on the other hand, you need to go into this assuming that you're going to have a totally uncooperative buyer. So therefore, you must know your rights and know your responsibilities. So I'd say have an attorney send a letter for the deed in lieu.
Oh yeah, well, people, in my experience, people take a letter from an attorney a lot more seriously than a letter from the guy that loaned them the money or the girl that loaned them money. Once they know an attorney's involved, they know things are going to get serious very quickly. They tend to be more proactive and try to resolve the situation, as opposed to, oh, I got a letter, I can ignore it. When he hires an attorney, then I'll pay attention.
Right. Now, the borrowers are soon going to learn, well, you're going to tell them they got 120 days before you can file. I would imagine we're going to have to deal with the fact that they know they can live there for 4 months for free. So you need to deal with the fact, at the very least, you might have to write them a check to get the deed back. You're going to write a check anyway, aren't you? One way or another, you're going to write a check to get the deed back, aren't you? Okay, a lot easier to do it peacefully. Now, I'm not so sure I'd want to offer that right up front. I'd want to see if we can't solve it peacefully, because you do have their credit in your hands, guys. Once you file that foreclosure, their credit is just dropped 80 to 100 points. Now, can I point that out to them in a letter, or is that violating the code?
Well, Truth in Lending and the Fair Debt Collection Practices Act both have a lot of restrictions on what you can and cannot say, what you can and cannot threaten. You can, in general, use generalities like, if you don't do this, it may have an adverse effect on your credit. Therefore, have you really said anything? Because it also may not have an adverse effect on your credit. So it all depends on how the person reading the letter reads it. You say, if you fail to comply with what I'm asking you for, it may adversely affect your credit. You've basically said nothing, although it sounds like you've said a lot.
Yeah. You know, I really don't want to create any harm in your life. I know you got issues of your own, but I'm sure you're aware that once I file foreclosure, it will go in your credit report and reduce your score tremendously. I don't want that to happen, and I know you don't either. That's different than saying, I'm going to wipe out your credit, moron, if you don't give me the house back.
Don't say that.
Yeah, don't say that. All right. Okay. Now, right now, I'd say if I offer them a deed in lieu and they don't respond, I'm wondering if I'm obligated to do anything else except wait out the 120 days, except maybe hit them another time or two with the same offer.
No, you have the duty to interact with them, but as to how many times or what you have to offer them, there's not even a guideline. You have to offer them some kind of loss mitigation. A deed in lieu is a form of loss mitigation. The funny part is that the big banks, before they'll even consider a deed in lieu, force the borrower to list the house for a short sale for 90 days. And they will not consider a deed in lieu unless the house is listed for 90 days, no offers are accepted, then you can apply for a deed in lieu. Whereas you guys will take the deed in lieu right away, which is, I think, a much smarter solution for both sides.
Okay, good. All right, now what makes me a mortgage originator? I can tell you, you don't want to be one.
Not if you're not licensed.
You don't want to be one even if you are licensed. How do I become an exception? All right, the rules are, A loan originator is a person who, for in any expectation of direct or indirect compensation or monetary gain for performing this following activities. Look, it's this simple. If you have anything to do with the process of putting borrower and lender together for a fee, you need a mortgage originator's license. However, is that what we're doing? Now, we're selling our asset and taking back a mortgage or deed of trust or a land contract. So unless we violate some provisions of the law that says we are a mortgage originator's license, like collect fees for doing stuff for other people, then in my opinion, that's something we probably don't need to give too much concern to. Agree? Huh?
No, I don't agree.
All right. Well, why?
Because if you look at number 1, performs any of the following activities, and they're commas, so they're all assumed to be ors, not ands, because there's a big difference between or and and. So number 1 says takes an application, and then we have to skip to takes an application, obtains or makes an extension of credit. Are you giving them credit when you're making them a loan?
All right. I'm the opposing counsel.
Go ahead.
We're arguing this in court. But Mr. Siegel, the first line says that I have to be a person who expects compensation, indirect or monetary gain, to perform this function. And I would believe that the law's intent was that if I'm doing that for compensation for the services of others. Your Honor?
Well, Your Honor, I would argue that another person is the person getting the credit. And so the person who's giving the credit is subject to the loan originator if they're making an extension of credit to another person. The other person
Your Honor,
being
since time
the borrower.
began, mortgage brokers and mortgage originators have been providing services to collect fees for the others. I see nothing in the law that specifically states that I can't sell a house with owner financing without qualifying as a mortgage originator. So, Your Honor, this is up to the interpretation, but I believe the intent was that if I'm performing services for other. Now it's up to the judge, and it depends on whether he got laid that morning.
Or just what he had for what he had for breakfast.
That's correct. All right. Okay. All right. Let's move on to balloons. Balloons are not permitted. You know what, though? While we're on that subject, why don't we just do it now? In here, I believe it says, in fact, I know it says at the end, that I think, and many others I've talked to think, it's probably not a bad idea for you to hire a loan originator to handle the paperwork when you're selling with owner financing anyway, because A, it takes liability off of you, or some liability off of you. B, that's their job, and they're not very expensive. I mean, for a few $100s, you can hire a licensed loan originator to be in the middle. And I mean, I can tell you for sure that puts a lot of weight in your favor that you intended to comply with the law, even if the other side wants to pick it apart, which they probably will. Again, he who has the biggest preponderance of evidence, and an attorney who can state that evidence and make the argument, is usually going to win. Now, you're not going to argue well on that one, are you?
No.
Okay,
if you
good.
have a licensed mortgage originator, you're in a much better position than someone who doesn't.
All right. Write down your questions. All right. Balloons are not permitted, but there are provisions allowing interest rates to rise each year. Must it be fixed for 5 years before increase was my question. How much can it increase? Okay. The answers were those restrictions apply if you're trying to fit under the exclusion to the originator rule as a seller financer. Once you are doing more than 3 loans per year per person or entity, all the provisions of Dodd-Frank apply. In other words, what Lee said, because that is his response, is that if you put a balloon in there, whether you think you're exempt or not, we're getting to exempt, you are violating Dodd-Frank as we read it. Is that correct?
Yes, Dodd-Frank says lender shall not make loans with balloons. Subject to the exceptions in Dodd-Frank.
Okay. So I'm having trouble with this one, to be honest with you. I cannot get a definitive answer from anyone on this one, likely because there is none, but I am absolutely going to keep searching until I find one, and that is, if I'm exempt, how can I be held accountable to the laws that I'm exempt from? It doesn't make any sense to me. And we're going to be exempt here in a minute, because the truth is, guys, your whole goal here is to be exempt from Dodd-Frank. Because if you're not exempt from them, it puts a lot of pressure on you to comply that we can easily exempt ourselves from. But unfortunately, the way it reads now, we can't be fully exempt, because there's a few things we got to do even if we're exempt. But let me finish that one first. It says down there at the bottom, the qualifying exclusions, restrictions on adjustable rates is that they can only adjust after 5 years and must have the margin tied to an index such as LIBOR. Additionally, they must have reasonable annual and over the life of the loan limits, and it appears that number is a maximum of 2% annual and 6% lifetime increase. The people that I've talked to, all right, here's my recommendations, which mean nothing to you. I'm selling with owner financing. I'm going to set that rate as high as I can on the front end to encourage my buyers to refinance as soon as possible anyway. And can't put a balloon in it. I'm absolutely going to put a 2% increase in that interest rate in year 6, and a 2% in year 7, and a 2% in year 8. Thus almost forcing them to refinance or making a very high payment, since we can't put a balloon in it. If I set the interest rate high from the beginning, then I'm giving them plenty of motivation to refi. However, there's a limit to how high we can set the interest rate.
Yes, under HOPA, you become a non-qualified loan if you're, I believe the number is 6.5% over the annual percentage rate. That's the market rate.
6.5 on a first and 8.5 on a second.
Correct.
Are all your sales to your buyers going to be seconds? They're going to be wraps. There's going to be an underlying loan underneath it, so they're going to be wraps. Even if you buy it free and clear from the seller and owe them, when you sell it, it's still going to be a wrap. Everybody understand that? So it's a second. So for all intents and purposes, your loan rate is maximum 8.5%, the way we read this. And then write your questions down. And in year 6, it goes to 10.5%, to 12.5%, to 14.5%, according to the law, according to the way we read it. All right? So how do I become exempt? Isn't that the big question? Don't originate more than 3 seller finance deals per year in any entity you control. That's one. Come back to that. Commercial deals are exempt, period, across the board, no question. Agreed?
Yes.
And loans to non-owner occupied buyers are exempt. That's what I'm told. I think you disagree with that.
I do.
Okay. They are commercial loans, as far as I'm concerned, and most other people is concerned. And there's evidence that this law is written for owner-occupied houses, but honestly, one of us is wrong.
Well, there's a conflict in the definition section of the Act, in that some definitions refer to the primary residence of the borrower, others refer to a mortgage secured by a dwelling. And a dwelling is just a house. Doesn't matter if anybody lives there or not. 1 to 4 family condo, that's what a mortgage is. So if you're a lender and you're making a mortgage loan, you're doing it on a dwelling, not necessarily a primary owner-occupied dwelling.
Yeah, and then I'm going to make the case that it is a commercial type deal provided to an investor. And honestly, I'm going to tell you from all the opinions that I've collected, they agree with me, not him.
Everybody's entitled to an opinion. They're like noses. Everybody has one.
They are. All right. Okay. Now, if buyer and seller are both an entity, excluded.
Absolutely.
So there's a case to be made there. Especially if I'm dealing with investors, that's easy. I'm an entity, they're an entity. So no problem with that. But there's a case to be made there to maybe sometimes create an entity if need be, just to make it apply. But honestly, I'm so convinced that it doesn't apply to non-owner occupied properties, I ain't gonna worry about it. Maybe I'll be your test case, huh?
Or you could just be safe and have entities on both sides.
But that's
then
not,
it is a
but
commercial
that's
transaction.
Not, that's going to be easy, harder than it sounds, Lee. When I'm dealing with owner occupants, hard enough to get them to understand what I'm doing. But well, actually, let's come back to that. All right. Here's some good news. I read it in there, and others read it in there, that I'm dealing with an owner occupant, and they're selling their primary residence. That they are exempt. But even if they aren't, I'm the buyer. I am the only one that even can create the issue. The sellers are the ones getting held liable for violating Dodd-Frank, not the buyers. So if the buyer doesn't complain, there is no issue. I'm the buyer. Got it? But I do have to resell. So in other words, when I buy on a balloon, if I buy with a balloon, and I don't have any problem buying with a balloon, but the only problem is how am I going to exit? Because I can't put a balloon in my exit. So the only thing I can do is what we just discussed. But it doesn't mean I can't lease option with my exit. Can I still buy with a balloon and lease option and give that lease option buyer a term much shorter than my balloon? Yes. I have no problem buying with a balloon. And again, I'm the buyer. And if I don't complain, there is no issue to even be concerned about. However, there might be an issue if I agree to buy with a balloon and then assign that contract and my new buyer creates an issue down the road. Agreed?
Yes.
So, you're not going to be able to do that. If you buy with owner financing and you give the seller a balloon, and you're going to have a little trouble on the back end because you can't put a balloon in it for the buyer. So that's even right now that's a bigger problem for Texas than any place else because you can't lease option it to the end of that term. So the only way you're going to be able to buy from the sellers is without a balloon, unless you intend to cash out of it. Because I wouldn't want you to assign that contract with a balloon to a buyer, especially when you know that buyer knows nothing about Dodd-Frank. So you're putting that buyer in a position to where you're setting them up for a legal issue later on down the line they didn't even know they had a problem with, which of course could bring you right back into the lawsuit. Agreed?
Yes.
Yeah, you set them up because you had knowledge. You're the investor. You're the one that should have known that passing that illegal contract on to them would put them in harm's way. All right, let's move on down to how do I become exempt? Well, let's go back to 3 deals. Your next question, incidentally, is if I become an exemption, well, the next one is, if I become an exemption, does the law, any of the law apply? And the answer is yes. Here's the part of the law that applies. Number 1, still no balloons, fixed rate for 5 years, and you must do some kind of qualifying that they have the ability to pay for the debt, even if you're exempt. The only part that bothers me about that was the balloon. That's the other part I do anyway. So what must I do or not do to buy and sell with owner financing? Well, buyers are the ones receiving the protection, and therefore none of this applies. Sellers who sell with owner financing more than 3 times per year will become mortgage originators and must comply with the requirements of Dodd-Frank. So if your entity sells more than 3 per year, you must comply with all the rules. Now look at the next question. Can I do 3 deals each in different entities if I control all? And of course you're going to get conflicting opinions on this one. What's yours?
Well, I think that's part of my answer I recognize in there. That's a very complex question. Corporations and control factors have many different interpretations by many different governmental entities. Now, the Dodd-Frank Act sets up the Consumer Financial Protection Bureau, and they're going to be the ones interpreting the violations and bringing cases. So if they determine a control person to be different than what, say, the SEC determines to be a control person, then you're going to get a different result. A control person is a term that can be defined by 4 lawyers in 10 different ways, because there's so many factors that go into what makes somebody a control person. So if your name is on the state website as the president, I'd say you're a control person. But what if your name isn't on the state website, you're the 100% shareholder, the president's your brother, and you just tell him what to do? Are you then a control person? Some would say yes, some would say no. If you're not an officer and director, can you be a control person? The SEC says absolutely. If you own more than 10% of the stock, you're considered an insider and you have some influence. If you ask the Consumer Financial Protection Bureau, I don't know what they're going to say because nobody's ever asked them.
All right. Now here's my interpretation and the feedback I've gotten from a couple of extremely good lawyers who've been in this industry for a long time. The answer is very simple. There is nothing in Dodd-Frank that defines whether they can be controlled or not controlled entities. Therefore, actually, what you just said is true. It's entirely up to the person or interpretation of whoever may be challenging you. But I have not found anybody else that has a problem with you doing deals in different entities, even if you control the entities. Now, if you want to be safe, then you do 3 deals in each entity and you don't control them, which is not that difficult to not do. By the way, the entity that your IRA owns, you don't own. That is definitely not you. And you better not be controlling it or you're self-dealing with your IRA anyway. The entity your wife's IRA owns, same thing. There's 3 deals each right there for you. The entity that your own entity and your wife's entity, whether your wife and you are the same, depends on who's challenging you. Now, do not confuse this with an IRS rule. You know, if I have 5 entities and I control all of them from a tax point of view, as far as the IRS is concerned, that's all a control issue, and it's kind of like one. But this ain't the IRS. These aren't IRS rules we're dealing with. They're Dodd-Frank rules. And you're going to find a lot of conflict in there. So in my opinion, well, first of all, most of you aren't going to do enough deals with seller financing to where this even matters to you. But if you just split those entities, I think you're going to be fine. And if I'm wrong, we'll send you cigarettes in jail.
And in Pinellas County, there's no more cheese in the bologna sandwiches, just so you're aware.
No more cheese in the bologna sandwiches.
Nope.
All right. Well, the good news is here, we're not talking criminal anyway.
No.
We're talking civil. We're talking money.
Yeah.
So nobody's going to jail unless you really do something incredibly stupid. All right. In fact, the next question is, what if the penalty? What is the penalty if I don't comply with Dodd-Frank and I'm not exempt? And I'll let you tell them.
Well, the consumer or the borrower can sue you and get back everything they've paid in financing charges over the last 3 years. What's worse is if you go to foreclose on them. They don't have a statute of limitations on asserting their defenses under Dodd-Frank, and they could use it as a recoupment or a set-off against you in the foreclosure action. So if the loan's 10 years old and they show a Dodd-Frank violation, they could still recoup the 3 years worth of finance charges and everything else they paid to you, even though that's 10 years ago. Plus attorney's fees and costs.
If you lose.
Yes.
Don't forget, just because you get sued don't mean you lose.
Unless you're sued by me.
I can't tell you how many attorneys have told me that.
He didn't have me defending you.
No, I can't tell you how many have told me that, and I didn't lose.
Because you didn't have me defending you.
Because you didn't have me prosecuting.
Exactly.
Prosecuting.
That's what I meant.
Yeah, okay, I got it. All right. All right, next. We sometimes do 10-year lease options when homes are over-leveraged. Will this be considered as owner financing? And if so, and it's really this simple. Now, from an IRS point of view, any lease over 3 years would be considered a sale. Mm-hmm. So let's start right there. Who cares? We buy houses from owner-occupants. What if it is considered a sale? What's the difference? It's tax-free anyway. It was their home. And if it's not tax-free, it's an installment sale. Pay taxes over the years, and that's on the fluke rare thing that the IRS would come in and audit them and say it's a sale. So, we sometimes worry about the wrong stuff. Besides, if I'm going to go in and the only time I'm going to get a 10-year lease is on an over-leveraged house, isn't it? It's the only time this even matters. On an over-leveraged house, if I don't get the 10-year lease, I'm not doing the deal. I don't care if the IRS considers a sale or not. But what if they do consider it a sale? My house is over-leveraged. I'm not going to get taxed unless there's a gain. How am I going to have a gain when I actually got to sell the place cheaper than what I paid for it in the ultimate end? So don't worry, don't go down that wrong trail for no reason. This is a different rule. What this says is, if it looks like a sale, it might be considered a sale, and if it's considered a sale, it has to comply with Dodd-Frank or be exempt. If you have a lease option that does give the buyer credit for debt reduction, it would be considered a sale. The buyer cannot acquire equity as part of the lease option, or it would be considered a sale. Correct?
Yes.
All right. Now, what that means is, if I'm sandwich leasing it and I'm installing a tenant buyer, it's irrelevant because I'm not giving them credit for debt reduction anyway. Am I? Hello? All right. However, if I'm doing a 10-year lease option from an over-leveraged client and they do get the benefit of the debt reduction and I assign that, could that be considered a sale?
Yes.
Yes? But it's my opinion that that sale from that residence is not going to be a Dodd-Frank issue anyway, even if it becomes an issue later. But as it says in here, there should be a disclosure statement at every closing involving any kind of owner financing or perceived owner financing that we believe this transaction does not come under, or we are exempt from Dodd-Frank, and it does not apply to this case. And that should be prepared by your attorney.
And that is one of the very important things to take note of. A disclaimer saying that and initialed off by the borrower is something that you can later bring up in court, because you say, you can't come and sue me now under Dodd-Frank when you acknowledged that this transaction was exempt from Dodd-Frank. Even if it wasn't exempt from Dodd-Frank, it was explained to you, you had an understanding of it, and you signed off on it, and it wasn't in 8-point font at the bottom of the contract, it was in 14-point font at the front of the contract. So it wasn't something that was hidden from you, wasn't something that we tried to trick you into. We told you up front. Now you're coming back 10 years later and saying you violated Dodd-Frank. Here's a disclaimer you signed. And so that may not win the day, but it's going to take you a long way towards winning the day.
All right. Well, in reality, most all litigation comes down to the true intent. So the more you go to prove the true intent, the better the odds are with you. How do we prove intent? We get it in writing. Remember the CYA letter? Yeah? We get it in writing. We get every point initialed. We get it done in front of an attorney so that there can be no argument, at least, that at the time you did it, the other party understood the deal. And if you don't do that, and you get to court, your word against theirs, and what mood the judge is in. The judge is going to have a hard time overruling physical evidence in front of him that the true intent was clearly disclosed. Now, that doesn't mean you're necessarily innocent, because you cannot override the law even with good intent. Here's something. By the way, are you going to read a lot of gloom and doom concerning Dodd-Frank? Oh, yeah, everybody's got their opinion. Now, let me ask you something. Could I get more people to come to my blog, subscribe to my email, and buy my magazines if I preach gloom and doom than if I'm positive? Now, people want to come and read the horrible stuff. So they have something to talk about, don't they? So you're going to see a lot of people out there, especially online right now. I mean, some of them are just printing totally false stuff to build their readership. And I just got a report from one of them. I don't even know who this is, nor do I care. But this is just the kind of stuff we're talking about. Historically, seller carryback financing was an option to help get buyers with damaged credit back into a home. However, the day of seller financing will soon come to an end. Is that what you want all your competitors to read? Yeah. So if they want it to come to an end, their choice. Not going to come to an end around my house. It's going to change a little bit. But if I'd have listened to that crap over the years, everything we do would have come to an end. I remember a time they were going to outlaw wholesaling. At least that's what the gloom and doomer said. And then they were going to outlaw subject twos. And then they were going to outlaw lease options. Well, they did in Texas. In fact, you know how the Texas law came about? Because I talked to somebody who really on the inside of that. The Texas, they did the law in Texas to outlaw collecting non-refundable option deposits. And the reason it went through is because nobody was disputing it. Nobody was disputing it. They passed a law, had no idea what they were doing. They only had one side of it, passed it anyway, and frankly, from what I'm told, later regretted doing it, but nobody's reversed it yet. You're going to see a lot of that crap here. Now, we're not even going to get into Obamacare. Huh? We're not even going to go there.
That's 10 days before Dodd-Frank. That's January 1st.
Mm. Now let me read you the opinion of an attorney, another attorney, a very skilled attorney I might add. It's been around forever and is a real estate investor on this number of deals per year. And you can do your own conclusions. You can do 1 deal per year as a natural person or trust. 3 deals per year in an entity without being licensed under Dodd-Frank. Do you know that? You can do 1 deal a year as a natural person and be exempt. That's your sellers. That's all your sellers. If your state has no exemption under the SAFE Act, which is another issue, is your state rules. Do you think the state rules are going to be much different than the federal rules?
No, as a matter of fact, in Florida, it incorporates the SAFE Act into Chapter 494, which governs mortgage originators.
So they didn't change them any?
No.
Florida has no rules that are different than in Dodd-Frank, SAFE Act. Okay. If your state has no exemption under the SAFE Act, you will have to use a licensed mortgage loan originator on every deal. In theory, if you are married and you both have IRAs, then that's 4 plus 4 plus 3 plus 3 equals 14 deals a year in various entities. That's a lot of leeway without having to get licensed. Remember, too, this is only a summary, blah, 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 disclaimer, disclaimer, disclaimer. Okay. On the fixed rate, I think we've covered that, actually. Since the new law apparently says the rate needs to be fixed for 5 years, a rate which is fixed to an index is a fixed rate. But, oh, this is a good point. It is the index fluctuation that is variable. So unless the law more specifically defines what is a fixed rate, I'm thinking that my fixed rate will be something like prime plus 12% with lots of discounts for early rent payments. I don't know about that. But the point that he's making here is that if your rate is tied to LIBOR, your rate can change without it being considered an adjustable rate mortgage. It's the LIBOR rate that is fixed.
All right, guys, I know that was a lot of information for you to absorb. In fact, probably created as many questions as it answered. By looking at the number of questions I have here, the answer here in a few minutes, I can tell you that I wished I could have cleared up all the confusion out there, but to be honest with you, there's nobody that can, because there's nobody who can tell you a lot of what this law says or doesn't say, because it just simply isn't clear. So we're doing the best we can, and again, as time goes on, these things are going to change, and we'll keep you updated on any changes. In fact, some of the things that I heard in the previous recording are really up for discussion right now, actually. So before I go any further, let me say it again. As soon as I get through talking about private lending and raising capital here, you guys can call in and present your questions orally. And the number for you to call, write it down right now, is 712-432-5480. That's 712-432-5480. And your conference line is 44039#, 44039#. Now, please do not call in and ask the same question that you've put on the screen. We don't need any duplication. And in fact, we've eliminated a lot of the duplicated questions already to take advantage of as much time as we have here. I'm going to talk about private lending here for a minute, and we're going to go right into questions. I'm going to take one from the screen, and then I'm going to take one live as long as our operator on the conference call has got somebody in the queue. So again, that number to get in the queue, if you're on the phone and not in front of the screen, or if you just want to talk, is 712-432-5480, and the conference call line is 44039#. Emily, I'm hearing some feedback on my end. I don't know if you are or not.
No, I'm not.
All right.
If you have your computer speakers on, you might want to turn them down if you're on there.
Do we have our computer speakers on? All right. Well, I'm going to get right to work here. We've got a lot to cover. And again, we have a 2 o'clock deadline. So let's first talk about is a private loan a security? And then we're going to go into this new rule about raising capital. I have long since believed that a private loan made especially to a non-owner occupant is not a security. And our attorney here, Lee Siegel, has done a write-up on this, actually, that is in the back of your Dodd-Frank report that you're getting on what we just covered. And by the way, one of the questions up here was, I've got the questions, I don't have the answers, and as I said going into the webinar, we're going to send you the answers tomorrow along with the questions and a copy of this recording so that you can download it again. And that will include what we're talking about right now as well as the previous 55 minutes with Lee Siegel in class. So here I'm going to read to you his answer to that question. Is a private money loan considered a security under SEC rules? In general, under the Securities Act, promissory notes are defined as securities, but notes with a maturity of 9 months or less are not securities. Securities Act, Securities Act 2, I don't know, I'm not, no sense of reading that to you. You won't get which act it is. Exchange Act, likewise, the U.S. Supreme Court sets a rebuttable presumption that a note with a maturity over 9 months is a security unless it resembles a type of note that is commonly not considered a security. And here's the big one. Reeves versus Ernst & Young, 110, Court 945, parentheses, 1990. So this is a 1990 case, and the Supreme Court in Reeves recognizes that most notes are, in fact, not securities. I've got some interference here. Most notes are not securities. The court provides the following list of notes that are clearly not securities, irrespective of their maturity. Here they are. Notes that fit into any of these categories are not securities. 1, a note delivered in consumer financing. 2, here's the big one, a note secured by a mortgage on a home. Supreme Court says it's not a security. A note secured by a lien on a small business or some of its assets. A note relating to a character loan to a bank customer. A note which formalizes an open account indebtedness incurred in the ordinary course of business. Short-term note secured by an assignment of accounts payables or receivables, and notes given in connection with loans by a commercial bank to a business for current operations. A disclaimer, it has not been proven in fact a private loan is or is not a security, as there is a lot of dissension on the subject. Our interpretation is that it is not considered a security based on the statutes above. Of course, nobody can represent that it is or it isn't because there's no case law that says one way or the other. I have long since held that it is not a security, but even if it is a security, frankly, it's not going to be one that should give you a problem of any kind, especially if there's only one investor. Now, I will tell you, if there's more than one investor in one note, it is absolutely a security. Anytime you pool money, it's a security. I want to talk about the new rules. We've heard a lot about the Jobs Act, as they call it, which supposedly goes out and gives us free rein to go out into the open public and solicit for capital. And there's certainly, we certainly can do that, but with caution. So the old rule is called Rule 506B, and the old rule simply said that we can go out and raise capital, but we cannot openly advertise for it. We must have a relationship with the people that we offer our investment opportunity to. And the old rule said that we could use both accredited investors and up to 35 non-accredited or non-sophisticated investors. That old rule still exists. So make a note, 506B still exists, and that's going to be pretty important in this conversation here in a second. In definition of an accredited investor is a family or a couple that has a net worth of over $1 million or makes a minimum of $200,000 per year or $300,000 income for the couple and has done so for the last two previous years. Now that is the rules for the 506B, which has been our long-standing method of raising capital. Again, to be honest with you, I do not believe that even those rules apply to private loans as we know them. But again, you know, that's the opinion of our attorney and several others that I've talked to. I don't want to be the test case in court on that as well. So I'm going to suggest that we comply with the SEC rules, even though I don't believe that it's necessary. Now let's talk about this new one that they've come up with that went into effect on September the 23rd, 2013, and that is the 506.3 section that has just been passed as part of the Jobs Act, which actually I think the Jobs Act was passed in 2010 or 2011 and didn't go into effect till September of 23. Now here are the problems that come along with this new act, and those problems are you can openly solicit for money now, but you can only solicit accredited investors, and therein lies the problem. The rules that come along with proving that they are accredited have vastly changed. So I'm going to read you an excerpt out of a publication by an attorney that I respect here, and I think it pretty much outlines what's required if you're going to use 506.3, the new rule. Verifying income from past 2 years' tax return. Now, these are things that the SEC uses as guidelines. Please make a note. There's no law that says these things have to be done. There's no specific way to prove that they are accredited investor. There's only guidelines, which, as far as I'm concerned, is one of the big problems with this law as well as the one we just discussed, the Dodd-Frank Act. If they would just make it clear and simple, it would be so easy to comply with it. But no, they don't do that. They leave a lot of it up for interpretation. So here's what they say. Verifying income from past 2 years' tax returns and written assertions that the income is expected to continue. Well, okay, that's great. How do you do that? Verification of assets by reviewing statement balances from brokerage houses or banks, reviewing tax assessments, third-party appraisals of real estate holdings, and verification of liabilities through an investor's credit report. Can you just imagine having someone provide you with their past tax returns, letting you pull their credit report so they can invest their money with you? In addition to that, obtaining a written confirmation from a securities broker, dealer, registered investment advisor, licensed attorney, or CPA who asserts that they have taken reasonable steps to verify the investor's accredited status within the past 3 months and the person is in fact an accredited. Can you just imagine any attorney or CPA issuing you a statement that they are under the opinion that that person is accredited? I think you're going to have a lot of trouble getting an attorney or a CPA to issue such statement and put themselves right in the path of harm's way. So even though they have opened up the new rule that we can openly solicit for money, my opinion and that of many, many folks that I've talked to is that you had better truly understand this rule very carefully and be willing to take some risk involved in raising that capital, because honestly it is going to be very difficult for you to comply with the new SEC rules as they've been laid out here and only deal with accredited investors and have a preponderance of evidence in your file that they are accredited. I am not saying that it cannot be done. I am not saying that it is not worth doing. I am saying, however, for the average listener on this phone call today, raising capital to make you private loans on your residences, that would totally prohibit that process as far as I'm concerned, unless you're going at it in a much bigger way. And I will tell you this, if you're going to do any kind of private placement where you pool money, you absolutely better comply with these rules. First of all, you wouldn't want to even dream about moving forward, raising capital through 506B or 506.3 without a good, or 506C, without a good securities attorney on your team. But here's the upside. The upside is in my opinion, I don't believe you have to comply with any of this stuff to talk to people about making you loans on your properties, and there's also regulations that state that if it's a business property, it doesn't even comply here anyway, and any loan that you acquire from a private lender to on a non-owner occupied house would fall under that provision as far as I'm concerned. So even though all of these rules are out there, even though all of the publicity is about it and all of the different varying opinions are out there, as far as getting private money from private lenders, as far as I'm concerned, it's business as usual, and don't make a big deal out of it, because you are not going to go out and raise money publicly and make public advertisements anyway. I'm suggesting you just go back to the old rule if that's what you intend to do. The old rule was not that complicated. It was not that hard to comply with. Just have some kind of relationship with the folks that you solicit before you solicit them. Now, for all of you listeners that are a member of our Gold Club, we've already got that set up for you. There's a website on our Gold Club that gives away a CD that I produced for you that you can drag down and use that says here, it's called Here's a Safe Alternative to the Stock Market. Well, that's all about giving them a free CD that explains to them what private lending is about. It does not ask them for money. Therefore, you've opened the relationship by giving away a CD, and you'll send that CD, and that starts the wheels rolling. That'll get them to contact you, and it'll also get you the information to contact them after that relationship is opened. So you are complying with 506B, in my opinion. So go back to the old way if you actually are considering raising any amount of private money. And frankly, if you're soliciting just for private lenders for a few house deals, I wouldn't worry about 506B or 506C. All right. I think we're ready to take questions now. In order to do that, remember, if you want to do them orally, you've got to get on you got to call a conference call line. That's 712-432-5480, and enter a code 44039#, and get in the queue, and our operator will take you in order, and I'll take those and I'll rotate them with the calls that I have here online. So, Emily, are you going to read the questions, or how are we doing this?
Yeah, I have a quick one for you. Will the attendees of this webinar be getting the report that you were reading from, or is there a location where they can download one?
I will make sure they get the report that I am reading from, in addition to the report on the Dodd-Frank Act tomorrow.
All right.
And this entire recording. Good question. All right, Emily.
How do you deal with the no balloon payment clause in the Dodd-Frank?
I don't deal with a no balloon payment clause because there will be no more balloons, according to Dodd-Frank, until that changes, and I believe that's one of the things that will change. I know that the national associations or realtors are lobbying to get that provision removed, and I believe someone will before it's over, because frankly that was the most deadliest part of Dodd-Frank as far as I'm concerned. That of all the rules that they've created, that's the one that hurts the most, because it will limit the way we sell houses with owner financing. Will not stop them. So I think we covered that in our recording a while ago. The way to deal with it is you need a fixed rate for 5 years. At that point, you can add 2% per year for the next 3 years to encourage the refinance, and of course increase the monthly cash flow if they don't refinance. But right now, balloons are gone.
All right. And here's one. I'm closing on 2 homes that I'm getting the owner to carry 0 interest and pay off in 15 years. Will it be legal after Dodd-Frank takes effect? They are both non-owner occupied properties.
Well, I believe that non-owner occupied properties are going to be exempt from Dodd-Frank anyway. Lee has a little different opinion on that, but I think any business loan is exempt. In fact, I know any business loan is exempt. So the only question is that a business loan or not? I believe that it is. However, if you can get those things closed prior to January the 10th, it's irrelevant anyway, because it won't fall under Dodd-Frank. It takes effect on the 10th.
Okay. You want to see if Ariel has a question?
Yes. Ariel, do you?
Yes, and our first question comes from Steve. Steve, please go ahead.
Hello, Ron.
Hey, Steve.
Just a question about lease option. I know we talked about the axe deals that are going to be over-leveraged. You did address that. I'm working with a seller right now that has about $25,000 in equity. I want to do a lease option with him and make it an axe deal because of the high payment. You still want to get his equity out, and so I can't put a balloon in at the end of this lease for him to get his...
Well, a lease and a balloon are not, you can't put a balloon in a lease anyway. You can put a term in a lease.
Okay. Oh, so that would not count as a balloon.
No. Remember, you're not selling the property, you're only leasing it.
Okay, so I sign this to another buyer, no problem. It's just the term of the lease ends in 5 years. And
Yes.
at that point, this amount is due.
Yes.
That's not considered a balloon.
No, it's not a balloon. A balloon only occurs when there's a actual sale.
Okay, so even though in this case the buyer would be, if they came up with 25 and financed, that's not considered a balloon. It's just
No,
they're just buying the property at whatever price we're agreed to at that point.
that's the end of the term. That's the end of the option to buy. It's not a balloon.
Excellent. That is very good news. Thank you so much for that.
You're welcome. All right.
All right.
Back to the whip.
If you put a property into a trust, then sell a partial beneficiary interest to a buyer, and then the buyer occupant lease options the property from the trust, is that transaction subject to Dodd-Frank, given their beneficial interest?
That depends.
Okay.
Because you didn't tell me how you're going to sell that to a buyer. I do know that a transaction from an entity to an entity is exempt from Dodd-Frank. So if you own it in a trust, that's an entity. If you sell it to an entity, that's also, well, it's an entity, so that would eliminate any question about the Dodd-Frank. But your question is actually not clarified enough for me to give you a real answer, but I doubt very seriously you got an issue there at all. First of all, if you sell if you sell a trust or part of a trust, you're not even selling real estate, you're selling personal property.
Okay. Ariel? Ariel's
Okay.
talking.
Our next question comes from Mark. Mark, please go ahead.
Hello, Ron. This is Mark. I was wondering how this might apply to lease options. So my situation is I have a property that I purchased from auction, and I have a buyer who wants me to, in a sense, own or finance it, but I'm going to lease with the option to purchase. Does this affect doing that strategy?
Mark, the only thing that Dodd-Frank has to do with lease options at all is that if your option, if your contract gives them debt pay down. So if you're going to stay in that deal, you wouldn't give them debt pay down anyway. Their purchase price is fixed, correct?
Yes.
Well, then it's irrelevant. It doesn't have anything to do with Dodd-Frank because it's a lease. It's not a sale.
Okay. So what if the deposit applies to?
Nope. That deposit is an option deposit. That is not, and it's only applicable if they actually buy. Therefore, it is not debt pay down.
Okay. So if I had the property and said that, you know, the monthly payment was $750 a month and $200 applied towards the purchase price, then that's subject to Dodd-Frank.
Yes. But remember, so what if it is subject to Dodd-Frank? Yeah, you remember the discussion about how many of these things you can do? 3 per entity, plus 1 for yourself, plus 1 for your IRA. Just if you're worried about it, just call it one of the deals that you would consider seller financing and be done with it. But honestly, and the way you described it, it is not under Dodd-Frank.
Okay, great. Thank you.
All right. Should you have a disclaimer or a disclosure statement about not being subject to Dodd-Frank legislation for lease option transactions?
Yes, Lee brought that up, and I absolutely agree with him. In fact, I'm going to make sure that going forward, anything that we sell with owner financing, they will sign a big disclosure that we say that it's not under complies with Dodd-Frank or that we're exempt from Dodd-Frank, and that they sign off that they agree. As far as I'm concerned, that's a great big preponderance of evidence in our file that they understood it wasn't a Dodd-Frank deal. It's going to make it very difficult for them to come back later and say that it was. And again, that only applies if it's a seller financing deal, guys. It doesn't apply if it's a lease purchase. But what the heck? Why not throw it in your lease purchase file as well? Doesn't cost anything. All right, are we back to live?
Okay. Our next question comes from Craig. Craig, please go ahead.
Hi, Ron. My question is, when you're doing lease options and you receive the down payment, you give them some credit from their monthly payment to the purchase price.
Mm-hmm.
When you go to evict, is that an eviction, or would that be that 120-day?
No, that's an eviction. That's an eviction.
That's an eviction.
As long as it's a lease option, it's still an eviction. Now, if they've given you a substantial down payment, they can always try to turn it over into civil court and call it a foreclosure. The more money you get down, the more subject you are of them taking it out of the landlord-tenant court. That's always been the case. That really has nothing to do with Dodd-Frank.
Okay, so the Dodd-Frank really won't stop doing lease options?
No, not at all.
Okay.
Not at all.
Okay, thank you.
This question kind of touches on something you answered, but asks, you said a natural person or trust can do 1 per year and 3 per entity.
Mm-hmm.
Assuming then, this is sort of a question, assuming then that a trust is not considered an entity?
Well, nobody knows. I'm going to consider it an entity, but the truth is it don't really matter. Remember the discussion about the 3 per entity for you, 3 per entity for your spouse, 1 is an individual, and 1 for your IRA. That's assuming you don't even have more than 1 entity. And if you're really going to do this and you're going to do a lot of seller financing deals, and create more than 1 entity. We have extensively researched this new Dodd-Frank Act, and there's nothing in there that says that if you have more than 1 entity and they're closely controlled, that it is considered 1 entity. That's in the IRS code. That is definitely not in Dodd-Frank. I specifically had that investigated. So I think you guys need to quit worrying about how many per entity. Just make sure you don't do more than 3 in any 1 entity, and don't make a big deal out of it. Remember, it says 1 per person. That also means that every deal you do with an individual seller that's a homeowner is exempt from Dodd-Frank. That's their 1 deal per year that they can sell. They don't even have a liability issue there. And that's important to remember, that when I'm dealing with a seller, that they are exempt from Dodd-Frank. Okay. Back to live. Ariel?
Okay, our next question comes from Kashmir. Kashmir, please go ahead.
Hi. I just want to know, how soon will these CDs be ready?
Tomorrow. We're going to ship you not a CD. Oh, you mean the CD that you paid for? Monday.
Yes.
Monday.
Okay. Will they ship out on Monday?
They will ship out on Monday. But remember, I'm going to send you the link to download it here shortly anyway, Mississippi Mama.
Yeah, because I'm going back to Ecuador this month.
Okay. Well, you'll get the downloadable link tomorrow.
Okay. All right. Thank you so much.
You're welcome.
Okay. Towards the end of the presentation, you mentioned that, this is a couple questions. You mentioned that sellers, I guess individuals, can only do 1 deal per year. And there's a number of questions about balloons. So does that include balloons?
Well, the general consensus is right now that even if you're exempt, you still can't put a balloon in your mortgage. To be honest with you, I don't see any. I haven't been totally convinced that that is true one way or the other. Frankly, I don't think that there's anything in the Dodd-Frank, at least that I or any of the attorneys that I talked to could find, that said that it is, if you do that 1 deal and you're exempt, that you can't put a balloon in it. But that's the stance we're taking now, because there's nothing that we can find that says you can put the balloon in it. So for the sake of protecting our clients, as of right now, I would say that the seller would be responsible for selling without putting a balloon in it. But after saying that, remember, I, the buyer, you, are the only ones that can create an issue. The liability is on the seller. It's not on the buyer. So if you are the buyer, then it doesn't make any difference what you do. You're the only one that can even create a problem. The only problem is if you buy it with a balloon, now you can't sell it and put a balloon in it. So now you're bound to lease option it. And, of course, you can put a term in it.
All right.
Go ahead with yours.
I am an investor in Texas that gets properties under contract on owner finance terms. And assign these contracts to end buyers. Can I still do this as long as there's no balloon payment associated with the terms on the
Answer is yes.
transaction? Okay.
Yes. Absolutely. Absolutely. And again, the question is still out there whether even you could even put a balloon in there from that one individual home seller. I'm going to do my best to try to get more clarity on that because that's an important question. But the way you just described the question, the answer is absolutely yes. You can assign them all day long as long as remember the three things. You should have a fixed rate for at least 5 years, and you should have no balloon. And the third thing was that there should be some kind of evidence that your buyer can afford the payments on the house in the file. Of course, you would do that anyway before you assign the contract.
Okay, got a couple questions here on ACTS. They want to know how this affects the ACTS deals, and are all the ACTS forms in the Gold Club updated for us after January 10th?
Well, there's really nothing else to update. The only thing you have to remember is that, yeah, it does not affect the ACTS, except remember that if I'm buying on a owner financing deal, right now I shouldn't offer the seller a balloon, and you can explain to them why. Tell them that our government has outlawed them, and they won't have to do much research to verify that. But no, so as long as that balloon is not in there and it doesn't violate one of the three, or actually one of the two things that I just described, and that is it must have a fixed rate for 5 years and no balloon. If you do that, you could assign that freely, and you won't have any Dodd-Frank issue. On the lease purchase deals, the only thing that is affected at all by Dodd-Frank is if you're doing a long-term lease purchase and the seller is getting, the buyer is getting benefit for equity pay down. And honestly, I can't tell you that you shouldn't even do that because, again, there's only a problem if the buyer creates one. But I think, especially in this case, I'd have a great big disclaimer sign that this does not comply, or this is exempt from Dodd-Frank. Make sure the buyer signs it as well. The safe thing to do is to not give the buyer the benefit of the debt pay down. But if you don't do that, then that's going to eliminate your grossly over-leveraged properties most likely.
Okay, more questions on an option deposit and how it affects. Now, do you want questions that are not specific to Dodd-Frank?
I'm okay with it. An option deposit is not part of Dodd-Frank. That's an option deposit. That is not a sale. Therefore, it does not come under Dodd-Frank, and it is not giving the seller equity, because an option means they may buy. It doesn't mean they're going to buy. If they don't exercise that option, then their contract is void and worthless anyway. It's not a sale. It's an option to buy.
Can a non-refundable down payment still be obtained when selling with owner financing?
Well, now owner financing, it's a down payment. It's non-refundable anyway. And of course, I don't know why I'd want to sell a house with owner financing and not get a down payment, as long as the terms of the loan don't have a balloon in them.
Okay. And someone's asking for a recommendation of an attorney in Oklahoma City or a couple others in their other areas.
You would have to go to your local real estate people to get that recommendation. Go to your local RIA group there, or go to realtors who deal with investment properties and ask them who their investment-friendly attorneys are. And that's what you're looking for, is an investment-friendly attorney or investor-friendly attorney. They're not going to be that hard to find.
Okay. I am partnering with others as equity partners. Let's see, I'm an LLC that will buy a property. Do I still have to qualify them as an accredited investor? That's the SEC question.
I'm not sure I understood that question. He's partnering with an LLC.
Yeah. He has equities. He has equity partners in an LLC that's going to buy the property. Does he still have to qualify the equity partners as accredited investors?
If the equity partners are going to buy a property, it's irrelevant. It doesn't even come under SEC rules. If that LLC, however, is going to be a lender and make a loan, and he already has a relationship with them, it's irrelevant anyway. So no, he does not have to qualify them unless it's a new LLC that he's doing, that is investing in a private placement, in which case he will have to qualify every member of that LLC. But the way I read the question, the answer is no. He doesn't need to worry about it.
Okay.
Let's see if Ariel's back.
Okay.
Ariel, are you back?
Hi, yes, I'm here.
Okay. You got some people in line?
Yes.
Let's knock out a couple.
Our next question comes from Daryl. Daryl, please go ahead.
Question I have is, will you be putting the disclosure form into the Gold Member Club having to do with the fact that this transaction?
I probably will, Daryl, but to be honest with you, that's about 2 paragraphs. I mean, think about it. That's all it is. It is our opinion that this property is exempt from the Dodd-Frank Act and the number of the act right after that, period. That's all it's got to say. Signed by seller, signed by buyer. You know, in fact, I put in there, it is our opinion, and you agree that this transaction does not or is exempt from Dodd-Frank. That's all it takes. But and you just tell your attorney that, and he'll create one for you. It's probably a little bit longer than that.
Okay. Some folks who came on late might not have heard this. They want to know when the law takes effect.
January the 10th, 2014.
Okay. Ariel?
Okay, our next question comes from Randy. Randy, please go ahead.
Thank you. Hi. You discussed assigning a note. I actually have 2 questions. One, there was a comment about the interest rate and charging, you know, the highest allowable or highest reasonable interest rate, for example, 10%. But then there was something about tying it to LIBOR. Is that reference to the increase or to the initial interest rate?
All right.
In other words,
here's the deal. First of all, it's not LIBOR. You can pick any index you want because they don't specify. Okay. So I picked the highest index that I could find. And then the general rule is if you're doing a first mortgage, it should not be higher than 6% above that. And if it's a second mortgage, which all wraps are, if you sell on a wrap, it's a second mortgage. And so that shouldn't be higher than 8.5%. And honestly, that's high enough anyway. I mean, you charge somebody 8.5% in today's market, that is enough, and that's probably all they're going to be willing to pay. But remember, you get to add 2 points in the 6th year, 2 points in the 7th, and 2 points in the 8th year. Or I'm sorry, yeah, 6th, 7th, and 8th. And so by the time it's over, you're 6 points higher than that. But if let's say you're using LIBOR, if the LIBOR rate changes, then that's not an adjustable rate mortgage. So if you're fixing this thing to 6 points above LIBOR, and LIBOR goes up a point, then you get to raise your rate on your loan a point, based on what I'm told.
but isn't LIBOR now like under 1%?
Oh, it's nothing. Yeah, it's nothing. So you might as well say if you're doing a wrap, it's 8.5%.
And if you're doing a first, it's 6.5%.
Yeah,
that's a pretty low interest.
Unless you can find an index higher than LIBOR.
Okay. There's been no discussion about selling or assigning the note.
Actually,
if there's any impact on the buyer of the note.
There's never going to be any impact on the buyer anyway. The buyer is not the one who would be held liable. It would be the seller.
No, I'm sorry, the buyer of the note.
Oh, the buyer.
In other words, if you create a 10% note with a 10-year balloon, and you go to sell that to a secondary to a note buyer or investor, is that investor impacted by LIBOR or by Dodd-Frank?
Well, I am sure that they would be, because if there was a suit to be had, it would be a suit from the buyer to the seller, which would automatically bring in the note buyer because they're the ones at jeopardy. So, I think your note buyers are going to be very careful to not buy notes that are violating Dodd-Frank rules unless they feel that they're exempt. And I'm only speaking for myself. I'm not a note buyer.
Right.
Yeah,
okay,
I'm sure their rules are going to change.
If I'm buying as an entity from a seller that's an entity,
you're exempt from Dodd-Frank.
Okay, and how does it relate to commercial unit properties?
Commercial is totally exempt from Dodd-Frank, period, no matter how you buy or what. You can do anything you want with commercial. Dodd-Frank does not affect it.
Do you mean Sherry?
Sherry, go ahead.
Hi, Ron. Thanks for taking my call. I think I'm following the gist of understanding that assigning lease options like an act deal doesn't really matter because you're just putting up the seller disallowed one deal.
No, does not matter with one exception, and that is if you're assigning an over-leveraged deal to a buyer, and that buyer is getting credit for debt reduction. Frankly, Sherry, it's not even your problem anyway, but you might be putting your seller in a position to where your buyer has reason to sue them later unknowingly. And I said at the very least, if I'm going to sign one of those, I'm going to get a form signed by the buyer that says that this is exempt from Dodd-Frank. That still doesn't mean that they can't claim that it isn't.
Well, my real question hinges on the fact that I own a number of properties that I have been successful in lease optioning out. That's how my whole business model. Am I not going to be able to continue that when I am the...
Well, first of all, whatever you've done is not this law is not going to go back. It's only going forward.
No.
And
right.
Second, your business model will not change as long as you understand the few things that you have to be aware of, such as no balloons, fixed rate for 5 years, and make sure your buyer can afford it, and put some evidence in your file to that effect, which is really nothing more than pay stubs and to verify that they even got income.
So I really have to finance them in this way for like 20 or 30 years, and with a 5-year term before the rate can change?
If you're issuing seller financing, and pardon me?
I can do lease options.
I'll say it again, Sherry. Lease options are outside of Dodd-Frank. Whatever you do within a lease option is irrelevant to Dodd-Frank unless you're giving the buyer equity.
I'm sorry. Okay.
You can lease option to your heart's content.
Thank you.
All right, I have an existing note with a balloon due this August. If the buyer is not in position to get refinanced by then, would I be prohibited from extending the balloon for some period since the modification would be after January 10th?
That would be a question that you'd have to ask your attorney, because I don't know whether that would qualify to be grandfathered in or not, because it was created prior to Dodd-Frank. I would say yes, because you're extending one, not creating a new one.
Okay, our next question comes from Pat. Pat, please go ahead.
Okay, two things, Ron. Number one, on a loan, isn't there an amortization where it shows a reduction in the amount that is owed in a normal loan? And number two, is there any other way of discounting the price of the house so that when we've done loans, the people pay their mortgages because they want the reward at the end? Say the house is worth $300,000, and within 5 years it's $280,000 as a reward for perfect payment.
That's actually a very good point. What was your first name?
This is Pat out of Cincinnati.
That's actually a very good point. If you want people to pay you off early, build in the incentives. No, there's nothing in Dodd-Frank says you can't actually let them pay you less than what they owe you. That's a good point. In other words, if you pay me off in year 1, you get a bigger incentive. Year 2, lesser. Year 3, a little lesser, all the way up to however you want to take that out. That's a very good point. In fact, you might even raise the price to compensate for some of the discounts. There's nothing Dodd-Frank says you can't sell the price for more than what it'll appraise for today.
Well, that's what I was thinking about.
That's a good idea.
Price, because normally we get 10% over what the actual value is anyway when we finance.
You just made the call, sir. Great idea. Raise the price, build in the discounts. And, yeah, there's an amortization coming along with every note. I'm not sure what the question is, but sure, they're all amortized. But that's nothing to do with the lease option question. And if you sell it on a note, it's already a Dodd-Frank issue. If you lease option it, it is not, unless you get debt reduction.
Okay, thank you.
All right. Ariel, let's go back to you. How many more do you have on holding?
I have one more caller in the queue.
All right, go ahead.
Okay, our next call comes from Vin. Vin, please go ahead.
Hello. If I have a question, if I'm exempt from the Dodd-Frank, am I still subject to the interest rate that is an index plus 6.5%?
From right now, from all of our exploration so far, the answer is yes, man. Again, I am not totally convinced of that. I would like to get some more opinions on that, but as of this writing, even if you're exempt, you still have to comply with no balloon and fixed rate for 5 years and evidence that they can make the payments.
And the index plus 6.5 as well?
Yeah. And, that was my question to the attorney. Well, how can I have to comply with rules from a law that I am exempt from? But, his general consensus is that even if I'm exempt, I have to comply with those rules. Again, the jury's still out on that. If I find out anything contrary to that, problem is I don't think I'm going to find out anything contrary because I don't think there's anything in there that addresses it specifically. So maybe one of you listeners out here would like to be the one that they pursue and take it to court to create the case law for the rest of us. We sure would appreciate it. Or maybe not.
In finding loan originators, do we find specialized registered originator in order to comply with both Dodd-Frank and the SAFE Act?
All loan originators have to be licensed today, and they can't be a loan originator unless they are. They're licensed, they're scrutinized, and the only reason to have a loan originator is that they're going to do the verification that they can afford the payments. That's all they're going to do. The loan originator is likely not going to make you compliant with Dodd-Frank. I mean, they should, but that's not really their job to act as your attorney. And honestly, I would probably, if I had any doubt whatsoever that that sale that I am making would fall under Dodd-Frank, I'd probably use the loan originator. But if I feel like I'm exempt, I may or may not use the loan originator. But probably wouldn't hurt to have one on your team just in case. They're only a few $100s. It's not really a big deal. All they're going to do is help you compile the package, basically, to prove if you ever got attacked that you did your homework and making sure you're complying with the Dodd-Frank rule that does say you have to have some evidence that they can afford the payment and that they have the income and so forth. Honestly, we've always done that. Always done that. But having a loan originator in there probably makes good sense.
All right. Is there anything in the Dodd-Frank that addresses a wraparound where the term of the wraparound is shorter than the term of the underlying mortgage? Underlying will be, okay.
No, not to my knowledge, but of course that's a dangerous thing now because, see, normally in the past that wouldn't have been an issue because I could have put a balloon in there. But now I can't. So that would be a dangerous thing to do.
On a deal where we sell a property rent to own with a down payment, then 84 consecutive rent payments, then they own the property for, say, $1, and then the deed gets quitclaim to the buyer. Is that affected by Dodd-Frank?
Absolutely. That is absolutely a seller financing deal because
Okay.
you're giving them equity. Now, don't forget, it doesn't matter. Suppose it is a seller financing deal. So what? Just call it one of the seller financing deals that you've done this year. Don't make, that's not a reason not to do the deal. But,
All right. If we're wholesaling a lease option or assigning our interest in an option, do we need to have an RMLO
no.
involved in?
Again, that wouldn't hurt, but that's just another expense your buyer's got to pay. I wouldn't, frankly, I wouldn't at that point, no.
All right. And if I take a house subject to that has an ARM on it, there's some acronyms in here that I'm not familiar with. Give to.
An ARM is an adjustable rate mortgage, and you can take them subject to with ARMs on them all day long. It's just that if you sell it with owner financing, you don't want to make it an ARM.
Well, the rest of it goes, give to TB under long-term lease option, but make TBs, tenant buyer, rent payments, vary according to the underlying ARM. Is this a financing arrangement that makes it subject to
If I take it subject to and I lease purchase it, Dodd-Frank is irrelevant. If I take it subject to and I sell it with owner financing, I just can't make it an adjustable rate mortgage. It has to be fixed for the first 5 years, then it can go up 2 points, 2 points, 2 points for the next 6, 7, and 8 years.
Did I ask you this question? How does Dodd-Frank affect land contracts?
I think we've answered it. Land contract is an installment sale, which makes it a Dodd-Frank issue. Again, no reason not to do land contracts. Just no balloon and fixed payments for 5 years.
All right. And in the recorded session, it was stated that Dodd-Frank applies to old loans as well. I have dozens of loans that I've made to buyers over the years in the form of a lease purchase contract. Again,
Well, first of all, no lease purchase contract is a loan unless it's given credit for equity. And if it's already been done prior to January the 10th, I would not be concerned about it. I don't remember anywhere in there where Lee said these applied to old loans. I think he made a statement about some of the banks are going back and fixing their old loans to make sure they comply, but that's their choice. I wouldn't worry about them.
There's a number of questions that relate to what if they've had a contract on a house and they've lease purchased or lease optioned, I guess a lease option, but they now know that their tenants are not going to qualify for a loan. How does Dodd-Frank affect that? This is prior, the people are in the homes already, they've already made these deals.
Well, then, look, if the deal was made prior to January the 10th, don't worry about it. I don't care if it's got a balloon in it or what. If it was made prior to January the 10th, it is not under Dodd-Frank. Now, as to whether you have a contract, maybe you have a contract prior to January 10th, but you haven't closed the sale yet, that's something you're probably going to have your attorney make a decision on. In my opinion, that still would be grandfathered in.
All right, and one of the last questions, someone's asking for clarification on a previous question that you may have answered about commercial units. 5 units, multi-unit residential properties. Instead of seeking private loans to fund my deals, I'm partnering with friends and family and business associates that I have a direct relationship with. Those individuals would be limited partner equity owners in the LLC that will buy the property, a different LLC for each property. In many cases, the seller will also hold partial short-term financing on the property. I understand that Dodd-Frank does not apply as long as the seller is also an entity, but do I have to qualify them?
All right, stop.
As potential?
First of all, if they're commercial deals, Dodd-Frank does not apply anyway, period. So no, forget Dodd-Frank if you're dealing with commercial deals, and commercial deals certainly is 5 units and above. As far as the other part about soliciting, they're all your relatives and friends and business associations. Therefore, you have the right to ask them for money, and you certainly would be complying with 506B, the old rules. So you do not have a problem. Nothing to keep awake at night about.
All right, and except for the question that just came in, all the rest of the questions relate to things that you have answered already. But the last one here says, can a buyer sign a deed in lieu at closing that the attorney holds in escrow? So if there is a later default, you have what you need to get the property back. It could
the answer is yes. A buyer can sign a deed in lieu at closing, but if they ever disputed that deed later, you would lose because that's a deed under duress. Anytime you make it a condition of the sale that they deed it back to you if they default, that's going to be easily overturnable if they actually take it to court. I will say it's a nice big hammer to have. It doesn't cost anything to get it. But if you actually use it and record it, it might cause you problems later. What if they come back 3 years from now and decide to sue you over it? And just think of the mess you'd have then. The best advice I can give you is get it if you want to get it, but I'd still take it through the foreclosure process unless they deeded it back to me at the time I actually took possession. And that is the smartest and the best thing for you to do. When they're in default, buy them out. Don't force them out. Give them money if you have to get the deed in lieu back right then and there, and then it's totally enforceable. A whole lot better than trying to skirt the law or create issues that could come back and bite you later. I always say if you're going to bury skeletons in your closet, at least know where they're buried.
And does assigning a contract for owner finance deal to an end buyer count towards the 3 deals per year?
No. They're not your deals. You're just assigning the contract. My opinion is they do not. You're not a buyer and you're not a seller. Do you have more questions, Emily?
I have one more. Okay, I know you said that if you buy with owner financing from a seller and the seller has a balloon payment in his loan to you, you can then start your interest at 5% and then bump it up 2% every year. Now my question is, how do we bump it up if we have to have a fixed rate for 5 years?
First of all, I can buy from the seller and do whatever I darn well please, because I'm the only one that could probably ever create a problem. So what I do between the seller and I'm not even going to worry about Dodd-Frank, even if it's got a balloon in it. Like I said earlier, I can buy with a balloon. I just can't sell with a balloon because now I'm the seller and I'm liable. I'm not going to create any liability issue for my seller. Secondly, I don't know where you got the 5% from. I didn't say anything about 5%. I said that if you're buying from the seller and they have a first, even if it were to comply with Dodd-Frank and you weren't exempt, which you are there, then the most that the seller could charge would be about 8.5% right now. I'm not paying the seller that amount anyway. So I guess the last question was, if you're going to sell and comply with Dodd-Frank and you're selling with owner financing, you simply create a fixed rate for 5 years, whatever that rate may be, and then it's built right into the note that in year 6 it goes up 2%, year 7 it goes up for 2%, and so forth. That's just part of the note, so it automatically goes up. Or you could tie it to the index and make it 6 points above blank index or 8.5 points above blank index, depending on whether it's a first or a second, which is the way I would probably do it, because the index is so low right now it can't go down much, it can only go up. So if the index goes up, I believe, based on what we're told, that your rate can go up without creating a problem with Dodd-Frank.
The Pennsylvania question is, because of the transfer tax in Pennsylvania, are there additional restrictions due to the Dodd-Frank Act?
No. Now, the transfer tax has nothing to do with Dodd-Frank. Pennsylvania is one state where I wouldn't use a land trust because they charge you as if it's an LLC. But no, nothing weird about Pennsylvania. Now, there are state laws, and then there are Dodd-Frank. As far as I know, there are no state laws that are even worse than the Dodd-Frank laws. I know that we discussed that with Lee, the Florida laws. There's no issues here, but you should ask your attorney, is there anything that I need to know about that isn't covered under the Dodd-Frank federal law? And the answer is likely going to be no. They did a pretty good job of making a big enough mess on their own. All right, Ariel, do you have any?
At the moment, we have no callers.
All right, Emily?
This is probably a good one that a couple of people have, is they came on late, and when will they be able to hear the webinar again?
All right, tomorrow we're going to send out the link for you to download the webinar, and we're also going to send you the report. The report going out tomorrow. The report with the answers to the questions in it are also going out tomorrow, and I'll send you this report on raising capital as well, all going out to you tomorrow. Those of you who ordered the CD, actually it's a DVD, will be shipped on Monday, and that DVD will be of just the whole thing. Okay, I don't know why you want a DVD, but you can listen to it, and there's not much to watch, as you can see on the screen. So, all right, Emily, are you done?
Well, you have a couple more that are coming in, some of which you've answered. There's just one here that's a bit slightly different as it relates to selling payments.
All right, well, let's do it quickly because we're at the end of our time.
Okay, you're saying that a lease purchase options, there's no problem unless it's giving credit for equity. So if the terms of the contract that I negotiated, I'm assigning the payments will be equal to the PITI on the property and the purchase price, will the balance on the loan at the time of the tenant buyer exercise the option be affected by Dodd-Frank? Is this a problem?
Well, listen, it can be construed that if they're getting credit for any equity, and they are, if their payment equals their PITI, I think I'd probably, to be real safe, just fix their payment to what the current PITI is, and until I find out differently, I think that's the safest thing to advise our listeners to do. Don't give them credit for debt pay down. Well, actually, my rent can be fixed to their PITI payment. No problem if it fluctuates. The only problem is if any part of that rent goes toward the debt pay down. So I'm going to rephrase that a little bit different to make sure everybody understands it. My rent can change, but if I don't get any credit for any equity, then I'm not under Dodd-Frank.
Okay. And let me do this so people can see we're still on questions.
All right, no more questions submitted now while we're live. If you have any more,
Right.
I guess you can submit them. If there's any more we don't get to, then I'll have Nick answer them for you, and I'll dictate the answers. Well, hit me with one more, and then we're going to get cut off. I know one question is can we have the parties waive Dodd-Frank? No, you can't have people waive the law. You can't have somebody sign a document that says, I choose to not comply with the law. No,
Okay.
it won't work that way. Even if they sign it, it's irrelevant. It will not get enforced or honored.
Here's a good one that you haven't touched on. Since the Mortgage Forgiveness Debt Relief Act was not renewed by Congress, what's the implementation in foreclosed homeowners getting deficiency judgments, 1099s, or loss to the bank, which, payment back to the bank, which would include foreclosure, deed in lieu, and short sale?
I've seen nothing that would indicate to me that the bank still doesn't have the right to come after a deficiency.
And on the last question, on a lease option, when the purchase price is the loan balance at the time of purchase, then they would be getting credit? That's a question.
Yes.
Okay.
If the loan balance is a purchase price at time of purchase, they absolutely are getting credit for debt reduction. And again, that would come under Dodd-Frank, but that is not a reason not to do that deal. So what? Even if it's construed as seller financing deal, so what? It's just one of the many, many, many you can do. And so I don't have any problem with you doing that deal. I would just want to make sure that everybody involved is aware that it probably would come under the Dodd-Frank rules. And then I'd want to make sure that it complies with the Dodd-Frank. There's only a few things that you guys have to do to comply with the Dodd-Frank. If you go back and review those again, mostly if you don't have a balloon, you don't have a fixed payment, or you do have a fixed payment for 5 years and you have qualified your buyer to some degree, you're actually complying with Dodd-Frank anyway. So I would not make it a big deal, at least the way this question was described to me. Full disclosure, let your attorney handle those things. I'm going to have to cut this off, Emily. We are over our time.
Okay.
About to get cut off. So guys, we'll take a look at the questions that you have submitted, and we'll answer the ones that have not been covered by email. Thank all of you for tuning in. I hope we have answered your questions the best we know how, and I also want to thank both Emily and Ariel for helping us with this undertaking. With that said, see you soon.